Hello, everybody. Right here. Billy, can you not sit on my phone, please? Please. Oh, come on. You are. Stop it. I wasn't running late. I was walking late. I tried. Like literally as it changed to it's showtime, my phone rang. I'm like, what the heck? It's my own fault. I decided to go on just a tad early. Hello, Nina Laura. Hello, Buzzy Pug. Hello, Wolf Lover. Hello, C-Rex. What you gonna do for it? Don't look at Earl. He's not gonna do anything. Earl won't do a darn thing. You're not gonna find what? Okay, were you looking at Earl because he took the brain cell? Earl's got the brain cell tonight. Hello, Iron Mother. Earl, what you doing? I built this tower with built-in scratchy posts. And he goes and uses the old cardboard scratchy posts that are by the door to go out. I did tuck one back in the corner, back in there. I tucked that A-frame one that he always liked. Tucked that in there. So every once in a while he'll go in that corner and use it. Hello, Dark Zoomy. If once you start down the dark side forever, will it dominate your destiny? I didn't read that was Master Yoda before I started reading that. I think I read that, more Shatner style. Hello, Jerry Matthew Boyd. Hello, Jerry Matthew Boyd. Hello, Jerry Matthew Boyd. I'm making up for last night, since I apparently passed you up like 5 times, supposedly, allegedly. BS. Hello, Charlie. Jerry, how dare you have a life? Not allowed. Well, I hope you have a fantastic night, sweetie. Thank you for popping in. We're going to miss you. I love you so much. Oh, you are so sweet. And I am so grateful that you stumbled across my feed. And knowing us, you probably actually did stumble. Look at you, you beautiful thing. 15 15 months. That's crazy. Thank you. I'm so happy. Hello, Sean. I can't believe you guys have been with me, most of you, for over a year. Some of you over 2. That's wild. Hello, XMO1. Speaking of 1 year. You guys are the absolute best. And she will. She will. That was tonight's dockets. I started early today. I was planning on going on this afternoon, and then you know what? I dozed off. But we're going. I know, me too. I actually just learned recently, supposedly, the way that I walk and my daughter is neurologically something to do with ADHD. Like when we walk, we sway around, like we lean around things rather than, like, I guess normal people will take a step over. But for my daughter and I, when we walk, if something's in our way, we just do this like hip slide as we go and just kind of weave in and out. And I guess apparently that's neurologically an ADHD thing. Like only people with ADHD do it. I saw some doctor on a YouTube short claim that. So I don't know if it's true, but wow. They said, "Do you walk like this?" And it showed a picture. I'm like, I do that. And, oh, you have ADHD. What? I might have. Hello, it's a Christine. See, I managed to miss most things ish. And I remembered, well, I was reminded why I stopped giving Ava those dang marrow bones. My toes hurt. I keep kicking them accidentally. I don't like it. I don't like it. I know. I love those little sciencey things, but you never know what you can trust anymore, you know? You could have 15 different professionals and they all say something different, if even only slightly. Why are you itching? You've had your flea medicine. I'm sure she's shedding. She's got dry skin, something along those lines, probably. Right, good girl? Right, good girl? Even with all of the eggs I feed you, you still manage to get dry skin. I gotta work some oatmeal into your diet. Or into your bath. I don't do baths very often with any of the animals. I only do them if I have to, because their natural skin oils are supposed to do the trick and you don't want to mess that up. So once in a while you have to bathe them, of course. But I try not to do it too often because I don't want to wash away all of their good biological stuff. haven't heard it that way before. I love that. I love that. Speaking of which, I might as well, She hasn't had these yet tonight. Oh, did you hear the balls? Did you hear the bright yellow balls? The quail egg balls? There's a cat in that gray one. There's a cat. Let's see if I can get this over my shoulder. No, I really can't. No, that was the opposite way. Hold on. There's one behind my back right now. Dang it. I didn't get any of them. Oh, that one's on the floor now. Dang it. It's hard to do when lefts are right and rights are lefts. And you're doing it behind you. Yeah. Oh, dang it. I almost had that one. Dang it. Oh, that one. I have another one behind me. Hold on. Let me go this way. And that was really not. That didn't work. That didn't work at all. This is not working. Well, the animals think it's working just fine. He was like, yes, this is working. This is working. Dang it. Why can I not get that thing? It's like every toss gets worse. They're behind me. And it came right back at my boob. Oh, dang it. Man. Oh, here's one that kind of broke. But it's like perfectly hollow on the inside, sort of. All right. What is going on here? Oh, well. I tried. I didn't make any of them. Did you give up eating them? Billy arrived. Here, go eat them. Go eat them. There's a bunch of crumbles and a few balls left for tomorrow. I'll have to practice. I need to get reusable balls, or I could always use the dehydrated chicken chunks. Earl likes those. Earl and Tiny Kitten, they'll eat those. Billy won't. Bandit won't. And Snitch, I don't think he's figured out that those are food yet. Hello, Eileen and Carlin. Because it sounded like a fun activity. Hello, Purple Kid. You're not late at all. Not a little bit. I've been on for 13 and a half minutes now. Well, 13, 53, 54, 55, you know. I might be. So we bit. But it's why you love me. Yes, all of them, other than Earl. His previous owner did that for me. He came ballless. Yeah. Billy likes to swat at Ava. Not Earl. Earl's Ava's buddy. Earl's everybody's buddy, other than Bandit. Bandit doesn't want to have a friend. Oh, Snitch actually cuddled with me today for like a whole 15, maybe 20 minutes while my cleaning lady vacuumed. Yes, I got my Medicare cleaning lady back. It's great. Finally. But yeah, he crawled up on the bed with me, and he laid with me, and he got so close, and it was so sweet and wonderful. I'm so happy. I am so happy. I love it. Snitch is a cuddler. Yes, thank you. Snitch, the new kitty. My new baby. Yep, he's Snitch because when you put him in the cage, he will tell on everybody to try to get out. I don't know whether that's Tiny Kitty or Snitch that's in the gray donut there. Tiny Kitten Esquire. I don't think Snitch has learned his name yet, so I can't really. Let's see. Does the pink one got anybody in it? I can't see. No, nobody in the pink one. Which one are you? Hey, I think that might be Snitch in there. Quite possibly. I think that might be Snitch. All right, so I got a variety tonight. I think it's mostly Michigan. Might be entirely Michigan. No, Gibson's, Texas. We got a bank robber. Well, no. We have a getaway driver that's shocked that he's charged with bank robbery. His shocked face is amazing. He just can't figure out how. Why are you charging me with something I wasn't even involved in? Well, when you're the getaway driver, you're involved. And he's lucky that nobody got pew-pewed because he'd have been charged with that too. Yeah. Oh, thank you. You're too darn sweet. Too bad he wasn't shocked in the literal way. Like, kind of shocked. I love when that happens. All right. So then we also have Judge Gauthier. So he'll be fun. And we have Judge Gibson. I don't think I've ever run her before. I think she's Texas, either Texas or Georgia, one of the two. I'm leaning towards Texas. My memory's broken. But what does she have? She does a lot of, like, I've never run her because she does a lot of really boring stuff. A lot of just two lawyers, giving probate details, and that's it. Nothing exciting. Today, though, State Farm is involved. Jake, probably. I'm sure of it. No. But yeah, the details of the case are quite interesting. So, love parties. I love parties. I don't think he says it like that. I've heard Gauthier and I've heard Gauthier. I've heard both of those, but I don't think I've ever heard it pronounced Gautier. Perhaps I'm not claiming that I'm perfectly right all the time, but I've not heard that one. Oh yeah, we're gonna hear a bunch of that. We're gonna hear a bunch of that. But she got me on the counter. Wasn't me. That she saw me on the sofa. Wasn't me. Hi, Tiny Kitten Esquire. Let's see, is there still a kitty in there? Nope, I don't see one now. Okay, it was you. Hi, beautiful. How you doing? Yes, yes. How you doing, baby? Oh, wrong button.
Bedford versus Maddie Toner, file number 268175PH. It's really Madeline Toner, but the petition reads Maddie Toner, so that's why the court stated as such. Case number 268175PH, the time and date set to challenge a personal protection order that was granted by this court on March 16, 2026. Both parties are present. Would you both please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Thank you. Back on March 16, 2026, the court received a personal protection order request. And that was requested ex parte, which means that it was requested without a hearing. And after the court reviewed the petition and reviewed the attachments, including a police report, the court issued a personal protection order against Ms. Toner. And in its reasoning, the court stated there were two separate acts of contact with the petitioner, including sending an intimidating social media message and alleged assault and battery and/or assault upon the petitioner. Ms. Toner is challenging that, and that's what this hearing is about. The burden of proof rests with the petitioner to continue the personal protection order. So I am going to ask Ms. Bedford to explain why you believe this personal protection order should be continued. Go ahead, please.
I have written a statement, and I do have a copy to turn in as an exhibit as well. Why
don't you just read it into the record, please?
Okay.
If that's your statement.
My name is Hope Bedford. Before the assault, I felt safe living in my usual routine. After it, my life has been constricted. I do not feel safe going out in public anymore, anticipating that I will run into either Heather or Madeline. This incident has changed aspects of my social life by making me question where I can be at with my friends without being attacked by these individuals. The physical injuries healed, but for nearly 2 weeks, sleep has no longer been restful as I could not turn off my thoughts. I have been anxious while at work and then have had to explain why I wasn't attending activities that I was attending before the assault. The pain wasn't only scratches and a busted lip, it has also been the daunting feeling of being stuck in fight or flight mode. I do not feel that it is necessary or required to be put in a situation again where I have to defend myself. This pertains to any physical and or verbal assaults in person or online that may be directed at me. Emotionally, I have been living with fear and anger simultaneously. I feel angry that someone else's actions forced revisions on my life that I had never asked for, modifications on where I go, what I do, and whom I trust have taken place in my life. I am only 26 years old, and I believe that I should not have to walk through my daily routine wondering what will happen to me next. I shouldn't have to walk around in fear. The fear and emotional distress I experienced are ongoing and directly tied to the incidents that led to the original order. I am most concerned about the retaliation that may take place due to me contacting local law enforcement. The night of the assault, I was completely humiliated in a room full of friends and patrons who frequently visit my place of employment. Madeline decided it was acceptable to put her hands on me and verbally assault me while doing so. I believe a termination to this order does not fully reflect the seriousness of the verbal and physical assault that I had experienced. I was the one who received the threatening message from Madeline. I was the one who was verbally assaulted and then physically assaulted on the night of the 14th. Therefore, I am attempting to protect myself and ensure that I won't be in any additional situations or with reoccurring scenarios. Since the incident, I continue to feel vulnerable. Madeline's past actions have demonstrated a disregard for my safety and personal boundaries. I respectfully ask the court to consider the sustained impact on my security, my work, and my mental well-being, and to establish provisions that protect me moving forward. My intention is not to escalate the situation, but to ensure my safety and prevent further harm.
All right. Ms. Bedford, your last name is spelled B-E-D-F-O-R-D?
Yes, Your Honor.
All right. Ms. Bedford, prior to, I obviously read the petition and I've read the response. Prior to February 13, 2026, was there a relationship, friendship, acquaintance between you and the respondent?
No,
No.
not at all.
Okay. And as I read in the petition, apparently on the 13th of February, you were at a local establishment. We don't need to name it, but you were at a local establishment. And what was your purpose in going to that establishment on February 13th?
My coworkers and I would often go to the wash after our shifts, as it is right down the road from our establishment, just to sit and mingle.
All right. And on that day, were there things said by you that caused some sort of stir in the room? Or explain what happened? What happened on that night?
Me and my coworker were having a personal conversation in regards to people who he had went to school with and people that I had known. And I had mentioned Madeline Toner's name, and we began discussing her.
Okay.
And
Let me stop you. You said a personal conversation. What does that mean?
as in, like, we weren't talking at a volume to where I would be concerned about what I was saying.
Okay.
But yet, it was loud enough that others heard you.
So are you stating that you're not, you know, for instance, let's say you were talking about me. Well, Prill is this, Prill's that. You know what I'm saying? The loudness and for all to hear. Are you stating that that's not what occurred?
Correct.
Okay. So you're having some sort of conversation regarding Ms. Toner. How did you know Ms. Toner if you really didn't have an association with her?
I used to be friends with somebody who was friends with her.
Okay.
Yes.
Okay,
So I
so-
never.
And I don't want to go into what may have been said by you, but something was said regarding Ms. Toner, correct?
Yes.
By you.
Yes.
What happened next?
Her mother had approached me and told me, I just want to let you know that is my daughter. I don't appreciate you speaking about her. And immediately I apologized.
Okay. How do you know that this is Ms. Toner's mother?
I had no idea until she had told me.
Okay. And was her mother also a patron that night or?
She was the bartender.
Oh, okay. She's a
Yes.
bartender.
Yes.
Oh, what terrible luck.
How far away were you from her when you were having this conversation with your friend?
I believe that as I was having this conversation with my coworker, she was walking up to the table.
Okay.
Yes.
So fair to say she overheard something.
Yes.
Okay. So you get confronted about it. Was it respectful?
No.
Why? Explain to me why you feel it wasn't.
She was very nasty towards me after, and I admitted, I said, I am wrong and I apologize. And it just kept going, and her volume just kept getting louder and louder.
Okay. After that happened, what happened next?
I had received a message from Madeline via Facebook Messenger, and I do
Is
have.
that the one that you
Yes.
submitted? Okay.
Yes.
Which court reviewed. Did Ms. Toner's presumed mother do anything to you at the bar? Because there's something about banning. Do you recall that? Did something happen at the bar that night?
I went to leave, and I was going to go and apologize to Miss Toner's mother again. And as soon as I put my coat on, she looked at me and said something along the lines of,
Well, we can't go to what was said, but bottom line, were you banned from coming back into the?
I was not, no,
No. Were there any words to that effect? Just get out?
just get out.
Okay. Did you comply with that?
Yes.
Okay. After you left the establishment, when is it that you claim this message was sent from Ms. Toner to you?
This message was sent while I was still sitting in the establishment.
Oh, okay. And just want to read it into the record so we have it clear. According to this, must not have anything better to do with your effing time, huh? Have to go and run your mouth at the local bars, question mark. Small town, word travels fast. Better watch what you have to, I'll say, effing say. Is that the message?
Yes.
How did you take that message?
As a threat.
Why?
Because the last sentence, you better watch what you have to say, that I took that as a threat because I did apologize when I was wrong.
Okay. So after the message was sent, anything go on after that?
I left the establishment.
Right, but any other communications or interactions between you and the respondent up until March 14th?
No, not between me and Miss Toner.
Okay, radio silence, right? No issues.
Yes.
Did you go into this establishment prior to March 14th?
No,
Why not?
I just avoided it.
Okay. However, you claim that you went into the establishment on March 14th, correct?
Yes, Your Honor.
And so we're talking a little over 2 weeks ago, correct?
Yes, Your Honor.
Okay, I'm just looking at the calendar. You go into the establishment for what purpose?
To celebrate a friend's birthday.
Okay, so you go in, correct?
Yes.
What happens?
I immediately after I walk through the door, the respondent's mother, Heather, was standing on her chair screaming my name. I did make eye contact with her, but I decided that I was just going to ignore her. And I walked over to a group of people, friends / coworkers that were in the establishment.
Was this person working that night?
The person we were going to celebrate.
No, I'm sorry, what you believe to be, who you believe to be Ms. Toner's mother. Was she working that night?
I don't believe so, no.
Okay, and was Ms. Toner in the establishment as well?
Yes, Your Honor.
Okay. Now, what happened after you claim mother was either yelling your name or made some sort of fracas here to get your attention? What do you claim Ms. Toner did?
After the statement was made, shortly after, I was approached by not only Heather, the respondent's mother, but the respondent as well.
Okay, and what happened?
Basically,
I think I made a fracas once. I think it involved some eggs and sugar, a little flour. Yeah, some salt. It was a pretty darn good fracas, if you ask me.
After you claim mother was either yelling your name or made some sort of fracas here to get your attention, what do you claim Ms. Toner did?
after the statement was made, shortly after, I was approached by not only Heather, the respondent's mother, but the respondent as well.
Okay, and what happened?
Basically, Heather decided that she was going to verbally attack me, and then she verbally assaulted me. And then shortly after, Madeline did the same as well.
What do you mean by verbal assault?
Just saying, like discriminatory things, calling me, cursing at me, stuff like that.
Okay. You allege in your petition, though, that there's something physical that happened as well.
Correct.
Now, let's focus first on respondents you claim mother.
Yes.
All I want to focus on is what happened in the establishment at the time. What do you allege that this individual did?
She shoved me.
Okay. Did you approach her?
No, I was approached by her.
Did you incite her in any way?
Absolutely not. No.
Okay. As a result of the push, is that when essentially all, for lack of a better phrase, all hell broke loose inside the establishment?
Yes.
Okay. What did you see, if anything, of what Ms. Toner may have done?
To me personally?
Yes.
She was standing in front of me. She was looking me dead in my eyes. She had pushed me. I went to defend myself. She had stated, "I am pregnant. You cannot hit me." So therefore, I took my attention off of her and back to her mother.
Okay. Did you confront her, Ms. Toner?
No, Your Honor.
Who approached who?
Madeline approached me.
Okay. And as a result of this alleged melee, were police called?
Yes, Your Honor.
Okay. Police responded
Yes, Your Honor.
and some sort of complaint was made.
Yes, Your Honor.
Okay. Why do you believe a personal protection order, in your own words, and I know you read your statement, I appreciate that, but why do you feel that we need to continue this personal protection order?
Including the other girl's mother. To be honest, it sounds like the other girl's mother was the biggest child of all of them.
I feel like the court needs to continue this personal protection order for my safety. I feel as if the personal protection order was lifted off, that there would be more incidents to be taking place. I feel like there would be more verbal incidents and even possibly physical incidents as well.
You placed in your petition that you were allegedly barred from going into the establishment. Do you recall that in your petition?
Yes. I want to say that personally, no one has reached out to me to let me know that I was barred.
Well, you've alleged in your petition that apparently you reached out to the establishment owner. Is that correct?
I don't believe so, Your Honor.
Did I read that wrong?
I believe that my dining room manager from my workplace had reached out to.
Okay, yes. Okay, that's right. In your petition, you allege that your EB
Mhm.
made contact. And were you indeed barred from the establishment?
Not to my knowledge, Your Honor.
Okay. All right. Anything else you want to add before I ask whether you have any other witnesses?
No, Your Honor.
Do you have any other witnesses?
No, Your Honor.
All right.
I will say this. She is a fantastic witness. She didn't get emotional. She stuck with the facts. She answered the questions that were asked of her. She did exceptionally well on the stand. Other than that letter, I thought that was a little much, but she had to get her feelings out. Get that. I get that.
Ms. Toner, this is your opportunity. How do you wish to respond?
So I received I was served with the PTO. I then went and filed a paper to terminate it. If you read the witnesses that have wrote statements on her behalf, my name is not included. This is an issue that happened with my mother, who is the bartender, and I don't feel like I need to be involved. Yes, I did send a message. No, it was not threatening in any way. I have never spoke to her. We were friends on social media. After I sent my message, I didn't find it necessary to have her on there because she was spreading my personal information around in the public that I didn't feel was appropriate. So I unfriended her. Unfortunately, I was put in the middle of a fight, or whatever you want to call it, the night on the 14th.
March 14th.
And I stepped in to intervene. When I stepped in to intervene, at this point, it had already escalated. And yes, I did make this statement. I am pregnant, but it wasn't something that, nobody knew at that point because it was already being spread around the town. I just don't feel like I need to be in the middle of it. If you read the witness statements, I am not the aggressor. I am not the attacker. Everybody had made that very clear. And as a result of what happened the night on the 14th of March, I ended up in the hospital with major abdominal trauma, which I have provided medical records for that.
Well, you provided records of conditions of treatment, but there's nothing did review it. It gives you steps on what you need to do.
I have the paper.
Let me take a look here.
With major abdominal trauma, she said.
Follow-up procedures, future appointments if necessary.
The triage patient summary.
What page is that?
It should be the first one attached after my statement. And it's down at the bottom, it says discharge diagnosis.
1:21 weeks gestation of pregnancy,
Yes.
2 trauma during pregnancy.
Yes.
Okay. All right. And I believe you allege in your response that someone had struck you, correct?
Yes.
Not a petitioner.
I was pushed, but I was pushed because,
Well, no, but please answer my question. The petitioner didn't push you or strike you, correct?
during everything that was going on, yes, I was pushed.
I didn't ask whether you were pushed. I asked whether or not you were pushed by the petitioner.
Yes.
Where did you list that in your response?
In my statement. Page 4.
Okay, you state Hope had pushed me into the bar and in self-defense.
And in self-defense to protect myself and my unborn child, I retaliated back and pushed back.
Okay. Did you review the police report that was provided regarding this as well?
No, because this whole incident is not being investigated by the Huron County Sheriff's Department. It's being investigated by the Michigan State Police.
Okay, but that night it was investigated by the sheriff's office, correct?
Correct. When I had given my statement, Officer, can I provide names or?
Oh, absolutely.
Officer Strzeski came out to talk to us, and at the time, from my understanding, there were no charges or allegations being pressed against me. They were all against my mother.
An individual by the last name of Indu, I-N-D-O, does that ring a bell?
Yes.
Who is that?
She's a bartender at the step.
And what's her first name?
Nicole.
Nicole? How do you know Nicole?
She's one of the bartenders at the Wash, and then she is a cousin, I believe.
Okay. And I don't have it in front of me, but according to the police report that the court had the opportunity to review, and I don't know why it's not here, but it indicated that the pushing or the behaviors really were focused on your mother and in part on you. There was nothing that I recall of any pushing. So
during,
and I could be wrong, but apparently the Michigan State Police is investigating this now.
yes, it was all turned over to them.
Okay, all right. Have you heard anything regarding the status of this?
I haven't spoke to them in probably a week.
So are you stating that the petitioner went up to you and pushed you?
During the fight, yes.
Where were you originally when all this started?
So after my mom had called Hope and her boyfriend by their name when they had first walked in the door, I said, it's time that we leave. I had already paid our tabs. I said, it's time that we leave. You know, I can already see where this is going. I said, we need to go.
Yeah, because clearly mom was already schnockered. The plaintiff said that the mom was up on the table calling out her name and her boyfriend's name when she walked into the bar. And now the daughter just kind of confirms that. I can already see where this is going to go. When my mom was calling her name. Yes. Yes, your mom's a drunk. And you're in the bar with her while you're pregnant.
We were waiting for my aunt. She was in the bathroom and my mom had walked up to the front, well, where the bar section is. And I followed her because she was already aggravated. And I said, no, it's time to leave. And I had gotten, after Hope and my mom had their altercation, I had stepped in the middle to try to de-escalate it. And
But you were expecting, why in the world would you do that?
there was a lot of drinking involved.
By who?
My mother, my aunt.
Well, why were you even there that night?
I was just getting dinner and I was their drivers back home.
10 in the evening?
Yes. They had been drinking and
They served dinner 10 o'clock at night?
They stopped serving at 8. Stopped serving dinner at 8 o'clock.
Okay. Does the last name of Koth ring a bell?
Yes.
The court recalls when it authorized the petition that you claimed that you were punched, or someone claimed, it may have been Zindu, that claimed that you were punched by someone by the last name of Cope.
Yes.
Is that correct?
Yes.
Okay. All right. Anything else you want to add to this?
No, I guess just after reviewing two different statements that I had been served with, and then as a copy of what was sent to me on 3/18, there's two very different stories. Like I said, in each statement from each witness, my name's not even listed. And I just don't feel like this is a situation that I need to be involved in when the problem did not originate with me to begin with.
Okay. Do you have any witnesses you intend to?
Not that I can present today, no.
Okay. All right. All right. Ms. Bedford? No other witnesses. This is your argument. Anything you want to say?
Yes, I do believe that these personal protection orders do need to stay in place for my safety.
But it's now alleged that you pushed Ms. Stone.
That is incorrect.
Okay, and maybe I failed to ask this, but I'm going to ask this. How is it, you described how Ms. Toner's mother confronted you. I guess I need to know, what is your side regarding whether you had any confrontation with Ms. Toner that night, March 14th?
So I was first approached by her mother, and then she was to follow behind her.
Did you move at all from your location when you were initially?
No.
Okay.
Nope.
So if you're stating that if Ms. Toner had contact with you, Ms. Toner would have approached you, correct?
I was approached by her.
Okay, and I'm assuming you're denying that.
No, I did approach her.
Okay,
After the statement was made, she had made the statement to my mom, you're an effing B, get out of my face. You can't tell me that I can't be here.
Okay.
And then she looked me dead in my face and said, the same exact thing, and you're an effing B too, get out of my face.
okay.
What I said previously, I guess I will use as my final argument.
Okay, fair enough. All right, same as in the last case, except this personal protection order was granted. The respondent may file a motion to terminate a personal protection order within 14 days of being served of it. She's timely done that. And the hearing is scheduled. The court has the opportunity to hear the evidence presented, and the petitioner has the burden of persuasion in a hearing held on a motion to terminate or modify a personal protection order. That's under the Pickering case of 253 Mishap 694 in 2002. The court heard testimony of a situation that occurred on or about, I believe, February 13 initially, 2026. Petitioner enters a local establishment, and according to her testimony, was with a coworker or supervisor, but again, friend or coworker, and they were a particular spot in this establishment, and they had a private conversation. Part of the conversation apparently involved the respondent. Come to find out, the respondent's mother works at the establishment, had clearly overheard what was stated, And as a result, there was interaction between the petitioner and the respondent's mother. As a result of that, according to the petitioner, she claims she apologized for her behavior, for making her comments, and for whatever reason, it didn't stop there. She attempted a second time, according to her testimony. And at that point, not even before the petitioner left the establishment, a message is sent, appears via Snapchat, and I'm going to read the whole thing into the record. I don't like doing this with the cuss words, but it bears repeating. At 11:37 p.m. Must not have anything better to do with your fucking time, huh? Have to go and run your mouth at the local bars. Small town, word travels fast. Better watch what you have to fucking say. I don't like saying that, but that's the message. According to the petitioner, she felt threatened by that message. Respondent says, no, that's not a threatening message. So the court has to consider that. Fast forward to March 14, 2026, and the court recalls in the initial petition that the respondent's mother had claimed to have barred the petitioner from going back into the establishment. However, the initial petition also indicated that petitioner's supervisor contacted the owner of the establishment, who stated there was no such barring. That was in the initial petition. March 14 comes along, evening hours, 10 o'clock, 10:30, whatever the time may be. Respondent claims she's there for dinner. Petitioner comes in. Petitioner has someone with her. Petitioner's boyfriend, I believe. I don't know if there were any other individuals there. I believe there were. They went into the establishment, and the respondent's mother, who was not working at the time, raises her voice, starts calling out the petitioner. All while this is happening, respondent is in the establishment as well. It appears to the court, according to the testimony, petitioner stood up, or I should say she stayed in her spot. Respondent's mother went and approached her. We have alleged pushing, and we also have the respondent, according to the petitioner, approach the petitioner and push her. That's what she stated. Respondent's position is, I was minding my own business. It's really my mother. And when I saw things were going bad, it's time to leave. So respondent attempts to leave. She claims petitioner went to her, pushed her, and then the melee that happens. Now, clearly there was one unconsented communication between the parties on February 13, 2026. Now, mind you, talking about other people can cause problems, clearly. And it did in this situation. I don't know the details. I don't want to know the details of what may have been said, but apparently there was a private conversation between the petitioner and a friend or coworker. Things were said, allegedly privately, still heard by respondent's mother, and that starts it. Before the petitioner leaves, as stated, the message was sent at 11-something in the evening. And respondent's position is, that's not a threatening message. Court takes judicial notice of the last sentence. Better watch what you have to effing say. Okay, we'll leave it at that. Fast forward to March 14, 2026. Petitioner re-enters the establishment. And I already brought up what the allegations were between the parties going on. And what I find significant to determine, because it's a burden of persuasion that is upon the petitioner to maintain the personal protection order. The response of the respondent is, hey, look, I'm kind of caught in the middle. that really involves my mother. I shouldn't be a part of this. I just want to be out of it, which is understandable. But petitioner claims she never approached the respondent. Respondent claims she did approach, but she was trying to get out of the establishment. That's what she stated. Petitioner said when she was approached, that respondent was in her face and get out of my face. Respondent claims that the petitioner also said that get out of my face. That would indicate to the court that the respondent approached the petitioner. Why would she state that? And why would the respondent admit that the petitioner made that statement if the respondent did not get into the face of the petitioner? That's the second unconsented contact. Regarding pushing, petitioner claims she didn't push, respondent claims she did, petitioner pushed her, but the court takes judicial notice of the initial petition in the police report, which indicated that the reason for the alleged trauma of the respondent was some sort of punch that was from a third party, unrelated to the petitioner. Court finds 2 unconsented contacts. Personal protection order is appropriate and it shall continue. That is all. Off the record.
So she gets to keep her protection order in place. And I think that that was just the appropriate decision in general. These 2 ladies clearly do not need to be in the same room as each other. Hell, they don't need to be in the same town as each other, but can't really do a whole lot about that.
Good morning, Your Honor. Susan Dunn on behalf of Mr. Rary. He waives formal reading, stands mute. We asked for a court-appointed attorney on the bank robbery. Plus, he's got a couple of 2020 DWLS cases, Judge, that we'd ask that you withdraw the warrants for. They're both FTAs.
All right, sir, please state your name for the record.
Malik McCrary?
Can you talk to Ms. Dunn today?
Yes.
She go over your rights with you.
Yes.
You understand all of those rights?
Yes.
Do you have any questions regarding your rights?
I just want to know, how am I involved in this, something that I wasn't involved in?
Sir, and okay, hold on. I can't talk to you about facts of the case, and I have no idea about your involvement in anything. The only thing I can talk to you right now about is your rights and whether or not you understand them as I cancel the warrants. We'll get to bond and your attorney will be able to argue with you, but I don't know anything about the facts of the case and I can't discuss that with you. That's something that we'll get you an attorney to take care of, okay?
Okay.
All right. Do you understand all of your rights?
Yes.
Do you have any questions regarding your rights?
No.
On all files, I'm going to cancel a warrant. I'm going to handle the 2 Frazier files first. It looks like on these, we are still waiting for arraignments.
Well, we would wait formal reading on that, Your Honor. I didn't realize that he hadn't been arraigned. I can do an application for a court-appointed attorney for both of those.
All right. Why weren't you appearing in court? You never even could get arraigned on these files.
I didn't know I had court. I paid to get out. I paid a ticket, so I didn't know I had court.
Sir, the last time I checked, bank robbery was not a ticket. So logic would dictate that that wasn't it.
For the traffic, for the Frazier, I didn't know I had court in Frazier.
I mean, bonds kept being posted, but then you would never come. All right, on both of those matters, I'm going to issue bonds in the amount of $500, cash surety 10%. They are traffic matters. These are on my docket. We're going to set pre-trials for April 7th, 2026 at 8:30 a.m. on Zoom. We will appoint you counsel. It's April 7th, 2026 at 8:30 a.m. on Zoom. Now we'll move on to the other file. On that file, I am also going to enter a not guilty plea for purposes of arraignment at this time. With regard to bond, Ms. Dunn, we'll start with
Judge, I
you.
asked Mr. McCrary if he had any priors. He indicated that he had one from 2015 he did time in federal prison on. It was some kind of robbery involving interstate activity. Other than that, he doesn't think he has any priors. I believe he door dashes for a living, so he does, employment. So we asked for a reasonable bond.
All right, and from the prosecution.
Yes, Your Honor. The defendant in this case is alleged to be the getaway driver in the bank robbery. He admitted to putting himself there and driving the individual away who did commit the bank robbery. And Ms. Dunn is correct. He did have a robbery from 2016, which was a federal case, but he also has a RNO from 2015 in Michigan. The fact that he has two robbery, he's facing this case as a robbery, but then he's already been convicted of robbery. And those both are serious crimes.
Hold on, I didn't. Listen,
Hold on,
like,
sir.
I
Don't,
never-
sir. I need you to
My
not make
bad.
any statements. We are being recorded and you are broadcasted live to YouTube right now. Anything you
Okay,
say
my
can and
bad.
will be used against you. You need to not make any statements. You can talk all about your side of things at your hearings with your lawyer. And you'll have all the
Okay.
rights to every hearing to defend yourself. But right
Okay.
now is not the time to make those statements, especially when you're being broadly live broadcasted to YouTube, okay?
Okay.
This is an open courtroom. All right, go ahead, counsel.
The fact that he's been previously convicted of armed robbery and that this is an armed robbery, there is a concern for the safety of the community. The fact that he was the alleged getaway driver in this case, there is a flight risk to this case. So at this time, and to coincide with his co-defendant, I believe is Nimmons, we're asking that their high bond, Nimmons' bond was $750,000, cash surety note 10%, and a steel cuff tether, GPS tether, if released.
All right, Ms. Dunn, anything further?
Nothing further, Judge.
Huh?
I already made my argument for a reasonable bond for Mr. McCrary, Judge.
Yes.
What do you mean, huh? What do you want her to say?
All right, I'm gonna issue bond in the amount of $500,000, cash surety 10%. GPS tether prior to any release.
So that's $50,000, 10%?
Correct. A PCC date of April 8th, 2026 at 8:30 a.m. on Zoom. I'm sorry, in person with Judge Bodecker. An exam date of April 15th, 2026 at 8:30 a.m. also in person with Judge Bodecker. So this matter will be heard before Judge Bodecker. You'll have your first hearing on April 8th. I've appointed your counsel. I've sent it over to the public defender's office to take care of that. And you'll be brought to his courtroom that day if you are not bonded out. The other matters will be heard before me on April 7th. Okay?
Okay. All right, all right.
Thank you, Your Honor.
You're welcome.
Have a good day.
Court-appointed application for the misdemeanor?
Please,
I don't
yeah,
think
just
so.
because they're gonna be separate.
I'll give it to your clerk.
Thank you. Can we have Skurzak, please?
Skurzak. Yes, sir. Troy, come on in.
Good morning, Your Honor. Susan Dunn on behalf of Mr. Skurzak. He's here for arraignment with a formal reading. Stand mute. He's asking for a court-appointed attorney on this felony case.
All right, sir, did you talk to Ms. Dunn today?
Yes, Your Honor.
Did she go over your rights with you?
Yes, Your Honor.
Did you understand all of those rights?
Yes, I do.
Do you have any questions regarding your rights?
No, but I am an idiot. That's all I want to say is I'm.
No, I don't want you to make any statements on the
Oh.
record. We are live broadcasting to YouTube.
Okay,
I just
sorry.
don't understand your rights.
Yep, I understand them. Yes.
And do you have any questions regarding your rights?
No, no.
I'm gonna enter a not guilty plea for purposes of arraignment with regard to bond, Ms. Dunn.
Judge, I'd ask for a personal bond. I don't think this defendant or alleged defendant has any prior criminal record. He gets disability. He's been living with his girlfriend for the past 40 years, staying out of trouble. I think this is an isolated incident. I'd ask for a personal bond.
40 years and he ain't put a ring on it yet? Oh, man. This guy is something. After 40 years? Honey, if he ain't put a ring on it yet, he ain't gonna.
All right, I'm gonna give a $10,000 personal bond, no contact with Christopher Kleiss. A probable cause conference date of April 8th, 2026 at 8:30 a.m. on Zoom. An exam date of April 15th, 2026 at 10 a.m. in person. You will be on my docket, sir. You will have that Zoom number on the disposition sheet when you're released from the jail. You either need to Zoom into me on April 8th, 2026, or you need to appear in my courtroom. Either one constitutes an appearance, whichever one works better for you. Okay?
Yes, Your Honor.
Shouldn't we have more on Slack? Do we just have, I could have sworn there were at least 2 things. And
No, they're the same report number.
you're all set, sir.
Thank you, Your Honor.
Right this way, sir.
I've been released on my,
Have a seat right here.
I have a question. When it says released on your own personal $10,000 on what? Put $10,000.
No, but you don't show court.
That's what I want. I'm showing up.
Is of truancy, 2 counts of truancy. I've received information from the attorneys that Ms. Molis is demanding her jury trial, so we will conduct our settlement. First of all, I have reviewed both of these files. I've been involved in them, and it's the court's understanding that at this point in time, we have no loose ends, and we are ready to go to trial on the 2 counts of truancy. The named victims in this case are Layla Mollis and Talon Mollis. Mr. Villar, from your office, who will be trying this case?
I will, Your Honor.
Okay. And Mr. Villar, do you know if the victims will be present for trial?
I don't think we have brought the victims in. I don't think that would be appropriate, actually, unless the court requires them. We have the school and school liaison officer to testify as to the missing days.
Okay, so you do have your witnesses and you have everyone that you believe would be necessary in order to prove your case?
Yes.
Okay, and they've all been subpoenaed and they're all ready to be here next week?
That is my understanding, Judge. They're ready.
Okay, are there any other witnesses that you intend to call?
No.
Any exhibits that you intend to use for trial?
Yes, we've turned over the exhibits that we intend to use for trial and discovery. They would include, let me see if I can find them all here. We have attendance records, attendance logs. We have attendance contracts. There's 3 separate attendance contracts. Parental behavior letter that we have. So yes, we've turned those all over as well.
Okay. And was an offer of settlement made to Ms. Wolfram on her client's behalf?
Yes, there was. It was an offer that we had hoped would resolve the case, but it was not able to resolve the case.
Would you be willing to tell the court what that offer was?
Yeah, our offer was to allow Ms. Molis to plead no contest to 1 count of truancy. In exchange, we would dismiss a 2nd count of truancy. We would dismiss the case of contributing to delinquency of a minor. And we would dismiss the companion family law cases going on in the family law court.
That sounds like a pretty darn good deal. You might want to take it and run. It would be hard to fight a truancy case, in my opinion. They've already stated that they have letters and, evidence and stuff against you. You're probably not going to win this one.
And they refused
Okay.
to accept that offer.
And Ms. Wolfram, you conveyed that offer to your client?
I did, Your Honor.
Okay, and she is rejecting that.
Yes, unfortunately, Your Honor.
And is there any sort of counter offer that Ms. Mollis would be willing to accept?
Even your lawyer is saying, unfortunately, when it comes to you taking that offer. You're screwed.
I suppose if there was further discussion regarding limiting, potentially like a deferred plea or something like that, where, if she completed some version of, community service or something like that, and we were able to, dispense. But I mean, I want to be honest with the court. My client is going to, based on the orders of the other court, have to continue to interact with this school. And obviously the custody case will continue regardless of, all of this. And unfortunately, because of those outstanding issues, that is why I'm very reluctant, and my client is very reluctant to accept offers of, responsibility or liability where she doesn't, fully believe that she has criminal liability because of the continued exposure and the detriment to her children.
So an offer was made for 1 misdemeanor and 3 misdemeanors would be dismissed. Also, a neglect and abuse case would no longer continue to proceed. And she is declining that offer because she has a domestic matter going on, and she would rather have 2 separate trials on 4 misdemeanors, as well as maintaining a case in family court on a neglect and abuse matter. Is that accurate?
No, Your Honor, she doesn't want any of these things, but
Well, I
unfortunately.
understand, but that's the election that she's making.
She is. She wants the opportunity to demonstrate to the court that she is not guilty of criminal behavior, Your Honor.
But she is. So she's not being afforded that opportunity. She is getting one hell of an offer that she should be jumping for joy for, being grateful for. She's getting a child abuse or child neglect case in family law court dismissed as a part of the plea deal. And she's not taking it. She's an idiot.
Okay, Ms. Wolfram, have you received all the exhibits that Mr. Villar has indicated?
I have, yes, I believe so. The attendance contracts and this, I think he called them school reports. I'm not entirely sure, but I did receive all of the information that both Mr. Blair and Mr. Villar have indicated they've sent to me with from the school.
Okay, do you have any witnesses for the defense?
I believe at this point I had thought that she was going to be part of it, but I think perhaps Deputy Kefauver's testimony will be important regarding the days. And then I may have to call somebody from the school as well, and then Aaron Lord.
And that's in reference to the truancy case, correct?
Yes, because the counselor provided some of the excusal letters, which will be an issue whether it's an issue whether a day is excused or unexcused, and she provided those letters. So I would need her unless the unless Mr. Villar is stipulating, because she did write a letter. So she didn't have contact. If we can stipulate to the letter, I wouldn't need her.
So any of your proposed exhibits, have they been provided to the people?
Yes. The letter from Aaron, that would be the letter from Aaron. I also provided homeschool records. And I know we refiled the proof of service on that when the court couldn't locate it the other day. So my client also was homeschooling concurrently. So we provided those records, the excusal letter from Miss Lord from Amplified Life. And then I don't intend to offer it as an exhibit, but I did provide the transcript from the abuse and neglect proceeding where the matter of truancy was already testified to on the record.
Mr. Villar, have you received all of that discovery? All those exhibits?
I'm looking in the file and I do not see the letter from the counselor or the transcript. Ms. Wolfram said that she could email those to me directly, but I do not see them in our file. So
I'll send it again, no problem. I did send the transcript this morning, just right now. So if you don't see it, let me know. And then I'll send the letter from Aaron as well.
And I've got the order of this court from March 19 indicating that the defendant is provided proof of service along with any documents, videos, photographs, recordings, or other things that the defendant may use at trial or reference in the presence of the jury. Can you, Ms. Carr, can you see on the ROA if we've gotten any proof of service?
See, March 19, court proceeding recorded, bond modified on case number 253848 SM, and I'm reading from a truancy file ending 847 SM. No action needed on this case. Order file emailed to P. Villar and D. Wolfram, as well as hard copies sent to prosecutor's office and mailed to defense attorney's office. And that was all done on March 19.
Okay. So we still have not received anything as far as a proof of service from the defense side?
We have not on file ending 3847. You want me to look at 48?
Well, I have nothing in my ROA either in the court's file. So Ms. Wolfram, I don't have anything still.
We'll get it hand delivered today. I'll get it hand delivered today.
Okay. Okay, I do have jury instructions on both files. And in reference to that first file, the truancy, Ms. Mollis, that is going to be our #1 case. That's going to begin at 8:30. The jury will come into the courtroom at 8:30. I want to be ready to go at 8:30. So please plan to be here prior to 8:30, ready to go. If for whatever reason you're not present, a bench warrant will be issued and the next case will be called. We do have another case not involving you, so we do have another defendant who will be here also. And if you're not here ready to go, that next case will be called. As you know, with a jury trial, if you are convicted, you could be sentenced that same day, and that could include jail time. You understand that?
Yes.
Okay. And in reference to the file 253848 SM, that is for 2 charges of contributing to the delinquency of children. Those are each misdemeanors that are punishable by up to 90 days in jail and fines of up to $500. Count 1 is in reference to, I don't believe that either of these say the children's name, but we know that it's Talon and Layla. So, same situation as the truancy case. Sounds as though an offer was made that's been rejected, and Ms. Mollis is demanding her trial in that regard also. There's nothing outstanding at this point in time. And no loose ends for the people. Is it going to be you also, Mr. Villar?
Yes, Your Honor.
And for your witnesses, who would you be anticipating for the contributing to the delinquency of minors?
And I'm going to have to switch my case here real quick. Hang on.
Sure.
Your Honor, in the first case, I would also like to say that we would have Brandon Strong as a witness as well.
And he is with the school, is that correct?
That is correct. I forgot to mention him. For the contributing to the delinquency of a minor case, we have listed Layla and Talon, Deputy Kefauver, and Mr. Molis.
Okay. And have they all been served to the best of your knowledge, Mr. Villar?
Yes, Your Honor.
And they're all available to testify next week as well?
That is my understanding.
Okay. Do you have any physical exhibits to be offered on that case?
Everything that we have has been turned over in our discovery and in our witness list.
Okay. Ms. Wolfram, have you received all of that discovery?
I have received it, although I did let Mr. Villar know this morning that the video, which I believe Mr. Blair indicated was to the contributing case, the audio is mostly unintelligible. I can't understand anything in it. Like the children are talking and the camera is somewhat picking it up. So I don't know what the video is purporting to present.
Yeah, and I have a feeling that contributing to the delinquency of a minor, it just sounds like house party, minors with alcohol, something along those lines. It also sounds like this is payback in the custody case. Like the charges were brought against her because her soon-to-be ex-spouse decided he was going to use it as leverage. I may be wrong, but I'm pretty sure I'm not.
So,
well, I have no idea because I haven't seen anything. So we'll just have to deal with things as they come up, unless it's a, Mr. Villar, do you know if that's a video issue or how it got provided to Ms. Wolfram? Does it work well on your end, I guess?
I do not have any idea on that, Judge. I haven't looked at, I listened to that audio and I told Ms. Wolfram that we can look at it, but I don't know if between now and if this case was going to go to trial on Wednesday, I don't know what we could do between now and Wednesday to fix that. But so if the delinquency case doesn't go, that would give us more time for me to verify, one, that our video doesn't have the same problems, or if it does, then it may be that the video is not going to be able to be used.
Okay, very good. Ms. Wolfram, do you have any witnesses for the delinquency case?
no, not at this time.
And do you have any exhibits or evidence?
I don't believe so.
All right, well, we also have jury instructions on this case as well. And if there are any special instructions on either file, they do need to be received by Ms. Carr by 1 p.m. on Monday. Now, typically I allow the parties a little bit of time to think things over and decide whether or not they're going to take a plea. These are usually at 8 a.m. and or 8:30, and we move things back a little bit to accommodate the parties. I will give you until noon on Monday, Ms. Mollis, to take a plea. Otherwise, I'm not inclined to take a plea. So again, trial starts up promptly at 8:30 on Wednesday. You need to be here, ready to go. And is there anything additional, Mr. Millar?
Just that I've indicated this to Ms. Wolfram, if we do have to go to trial and there is a conviction on one or both of the truancy counts, I will be asking the court to give Ms. Mollitz jail time. And as part of our plea agreement, we had indicated that we're not going to be requesting any jail time, and we would be silent as to whether the court would want to put her on probation or not. So that was part of the plea agreement. But if we do have to go to trial, I will be asking for jail time.
And ultimately, the court will make that determination. But the court does take recommendations seriously, and I certainly take those into consideration when fashioning sentences. So, anything additional, Ms. Wolfram?
I just wanted to clarify, for some reason, I'm not at my office. This is for April 1st at 8 a.m. Is that right?
Correct.
Thank you, Your Honor. Nothing further.
Okay, we'll see you bright and early on Wednesday.
This is calling case number 25002354, and I, Tracy Cross versus Janelle Scott Nunn.
Council appearances for the record.
Jason Keith on behalf of the plaintiff.
Marina Sambu on behalf of defendant Scott Nunley.
Rand Hirsch on behalf of State Farm for PIP.
Nina Rosenbach on behalf of State Farm for the uninsured motorist claim.
Okay, and Ms. Sambu, this is Scott Nunley's motion. I know we put this over, right, for supplements, correct?
Yes.
Okay, so refresh my memory. Go ahead.
So defendant Scott or Mrs. Scott, Miss Scott, lent her vehicle to her brother. Her brother had the vehicle. At about 1:30 a.m., he was carjacked. The vehicle was taken from him. He went to his sister. The next day, they made a police theft report, and it was communicated to my client that the vehicle was involved in an accident that happened at about 3 a.m. So the vehicle was reported stolen. It was stolen. And honestly, there is no reason to not dispute that it wasn't stolen.
That's a pretty convenient fact pattern there. You're carjacked at 1:30 in the morning. You do not report it until the following day when you are informed at that time that it was involved in a car accident around 3 a.m. If I get carjacked and my sister's car is stolen, I'm calling the cops right then and there. Why would you wait? It doesn't make sense.
So we're requesting or we're asking for summary disposition pursuant to MCL 2116C10.
Mr. Keith.
Your Honor, there's no admissible evidence here that the car was stolen. The only evidence that the defendant has provided the court is a UD-10, which doesn't come into evidence by statute, and a theft report, which doesn't come in either because it's hearsay. 2 days ago, we finally got the deposition of the defendant. So we don't have a transcript yet. But what she said was she had no personal knowledge of the carjacking. She had no personal knowledge of the accident. And most importantly, she had no knowledge of the whereabouts of her brother who was allegedly in this accident. Nobody can find George Scott. We don't even know if he was driving the car, other than hearsay evidence. There's nothing admissible. There's nothing to base their motion on. As a matter of fact, defense counsel for State Farm and the UM just filed their own motion for summary disposition yesterday to have the court rule that the car was not stolen as a matter of law. And I'll probably concur with that motion because there is no evidence that the car was stolen. Nothing admissible. So I ask that their motion be denied.
Anybody else need to add anything else?
I want to respond to him.
I'm sorry.
I'm sorry, I was just gonna say, I agree with everything that plaintiff's counsel said. There's been no evidence of a carjacking presented to this court or to any of the parties, so we are also asking that the motion be denied.
Okay. Ms. Amber?
So there's no evidence that the carjacking didn't happen. The plaintiff testified that she didn't see the driver. She never spoke with the other driver. The police report says that the witnesses did not identify the driver. There is no evidence that it did not occur. My client made a report. The police officers, if they felt that she was lying, would not have issued that report. There's a theft report as well, which shows that the vehicle was stolen.
Your Honor, the theft report was done by George Scott, who can't be found. We don't have to prove that something didn't happen. They have to prove that something did happen if they want the court to make a ruling as a matter of law that the car was stolen. We've got nothing here that's admissible in a court of law showing that the car was stolen or that this carjacking even occurred.
All right. And if this went to court, we wouldn't have anything. And it does create a question of fact. So taking evidence like most favorable to the non-moving party, the court will deny the motion for summary disposition. I know today I'm sorry.
I'm sorry, go ahead. No,
I was going to say, I know today we also had, we were scheduled for, I believe, our first settlement conference, right?
Yes.
Yes.
And Ms. Rosenbaum, you said you filed your motion when?
Your Honor, we filed it yesterday, but I believe it was rejected due to something with the exhibit, so it was refiled this morning.
Okay. That being said, yeah, I'm sorry.
I'm sorry, I keep cutting you off. Regarding the motion, can we clarify if that's with prejudice or without prejudice?
At this point in time, it's with prejudice because I adjourned it once before for subsequent information to be presented to the court.
Okay.
Give me 1 second. What I want to do is put the settlement conference out a little bit because I know Ms. Rosenblatt, unfortunately, we're scheduling SDs out a ways. And I want to see where we are short of waiting for that to be scheduled. 1 second. Yeah, this case isn't that old. It was filed in February of 25, so we've got some time. But I think what I'll do is put this out about 30 days, and then we'll return for a settlement conference. Hey, give me 1 second. And Ms. Sambal, in your order, can you put the new settlement conference date once I give it to you?
Yes, Your Honor.
Okay, thank you. Give me 1 second. Let's say April 28th at 11:45 for a settlement conference.
Via Zoom, correct?
Yes, via Zoom. April 28th, 11:45 via Zoom. And Ms. Rosenblatt, make sure we have a hard copy of your motion.
Yes, Your Honor.
Okay.
Your Honor, if I may.
Yes.
Having a settlement conference before the motion is heard might not be very fruitful.
But we'll talk about it because we need to talk about it because I need to see what's going on because I'll make that determination in terms of what we need to do. And there may be some other things I need to do to move it up or something. So we can discuss all that at the settlement conference.
Okay, thank you, Your Honor.
All right, thank you all. Like I said, we'll see you April 28th at 11:45 here. So
Thank you.
Thank you.
Samba, I'll look for your order. Thank you very much.
Thank you.
Take care, everybody.
All right, good morning. We are on the record in the 53rd Circuit and we are providing public access both in the courtroom and also online. And we have a short docket this morning. First case is People of the State of Michigan versus Spencer Hope. It's file 26-7142 FH. Counsel, you want to state your appearances, please, beginning with people.
Melissa Goodrich, Wayne County Prosecutor.
Daniel Price with the defendant who sits to my right.
All right, and we have, this is scheduled for an arraignment and pretrial for a scheduling order, and there's also a bond motion that's been noticed up. So for purposes of the arraignment, Mr. Price, if you had opportunity to review the charging document with your client.
Yes, I had, Judge. We would waive the reading of the charges, and my client elects to stand mute. Or
Okay.
mute, excuse me.
All right, so we'll enter a plea of not guilty on his behalf to the 2 counts of felonious assault, domestic violence, 2nd, child abuse, 4th, and reckless driving. Is a forensic center referral requested?
I'm sorry?
Is a forensic center referral requested as to competency or criminal responsibility, sir? Or no?
No, not at this time.
What would be the estimated length of trial? including
Probably
selection?
3 days.
Okay.
Yeah, I do have one of the victims in the Zoom waiting room that wanted to attend via Zoom,
Oh, okay.
and the victim advocate.
Okay, I do see iPhone, so thank you all and that person. We could schedule this for, I know different, Mr. Price, I haven't had a case with you, different counties call them different things. Here we call it a docket call, like a jury status conference or a pretrial that we schedule just to touch base as whether the case is resolved or whether there's any motions that could be noticed up that same date and time, or whether we need to put it on our trial docket. So we can come back for a docket call on April 28th. I do allow, if you need, appearances by Zoom, video conferencing, or in person is fine. Is morning or afternoon better for you, sir?
Either or, doesn't matter to me.
Okay, why don't we put this then for April 28th at 10:50 a.m. And I'll indicate that Zoom appearances would be authorized. And then anything further from the defense in terms of scheduling order, sir?
No, that would be for the purpose of the status, and then we would set trial after that. Is that?
Yes, sir. Unless you know for certain, you just want me to put it on our trial docket and get some dates.
No, I just want to make it that it's clear in my mind. Thank you.
Okay. Ms. Goodrich, anything further from the people for scheduling?
There, thank you.
Okay, Mr. Price, through predecessor counsel, Mr. Hope had filed a motion to address bond conditions. Did you want to press that motion today, sir?
Yes.
Okay, go ahead.
Thank you. Let's the district court here in this county set a bond in on November 3rd, 2025. That conditions of bond prohibits contact between my client and his daughter, who's a minor child. Excuse me. My client is going through a divorce in Emmett County. And on January 28th, there was an amendment or amended PPO order that's connected to this case that allowed my client to have at close contact with the mother of the child solely concerning the child, and with the child to exercise parental rights via video chat, no in-person, no phone calls, just through at close. Prior counsel did get a stipulation to that amended PPO by the divorce attorney for Ms. Hope. Prior counsel in this court attempted to obtain the consent of the prosecutor to amend the bond here. She's indicated to me today, and he indicated in his motion, that she could not agree based on the alleged victim statement to her. We're only asking that my client be allowed to exercise parenting time with his child. If he could set it up with his child, he would. He wouldn't need to contact the mother of the child. Unfortunately, that can't be done.
Isn't the child one of the
Alleged victims.
one of the alleged victims in the case as well?
Correct, Judge. I mean, after getting involved, because I'm now handling the divorce case.
Okay.
There's a couple of motions in that case, excuse me. Too many years of smoking. One of which is to set aside a restraining order. The other of which is to defend an alleged violation of that restraining order.
If the child is a victim in his case, a victim in any context of the word, then he should be thanking his lucky stars that he's having up close communication with the child, period. It is so rare that someone is allowed to have contact with a child that's a victim of their crime.
after reviewing all the facts and talking to witnesses, I will show in that court that the basis of the restraint or the restraining order, as well as the motion for show cause, is based on fraudulent statements by the alleged victim in this case. My understanding of this case is my client was basically set up. He had no time admitted to any of the allegations against him. The police on the scene pressed him 2 or 3 times, and he said the same thing each time. I don't think he poses a threat to his daughter.
Okay, anything else I need to know to understand your position?
I'm sorry.
Anything else I need to know to understand your position?
If you'd like, I can read that amended PPO to specifically state what we're looking for.
No, that's fine. I mean, I think I understand the requested relief.
Okay.
Okay. Thank you. Ms. Goodrich, people's position.
Your Honor, I would ask the court to deny that motion. That would be unusual in a victim case. This child is a victim in the crime. It's not just a child that they have in common, separate from this crime. She was part of it. The court has the affidavit. This was where they're pursued by Mr. Hope in a vehicle. So there is cause for concern of having any contact at this time. The victim is concerned as the mother for having any contact with her child at this time. I did reach out to the divorce attorney as well to see if there was anything unusual about why they did this in the PPO. There was nothing to, I guess, change my mind as to maintaining wanting a no contact with both victims in this case.
All right, thank you. Mr. Price, in a rebuttal argument?
No, only to reinforce the fact that the divorce counsel stipulated to the amended PPO order.
Okay. I mean, and there's different considerations in a divorce case and in a PPO case and in a criminal case. There's a lot of overlap. The Venn diagram would, have a lot of overlap, but there's, some considerations that are different. The requested relief is to amend the bond conditions to allow video contact only. So that would, address any concerns about the physical safety of the child. But in a criminal case, there's some considerations that even go beyond that. I understand Mr. Hope's, presumed innocent, and it's from the statements of counsel, he takes issue with some of the allegations or the context of the facts that are alleged here. And he's got all his rights to pursue those and have a jury determine those things. But he's charged, and there's been a probable cause determination with child abuse and felonious assault with this minor child as the alleged victim of that. It would be quite unusual for a court to allow contact with that victim, even by video, for a child to have witnessed what was alleged. If those are true facts, at this point, there's a probable cause determination of them. Would be a difficult circumstance for that child to process. So I would think that there's a risk that even video or telephonic contact with Mr. Hope would present a risk of undue emotional, psychological harm or pressure on the child regarding what her testimony might be. So I'm going to deny the motion to amend the bond conditions. We'll see you on April 28th at 10:50 a.m., Mr. Hope.
Thank you, Judge. All the other conditions of bond remain the same.
Yes, sir. And I'll just note that on the criminal scheduling order so that there's no proposed order that you need to submit. All right, thank you.
Thank you.
Thank you.
We're back on the record and resuming our live stream. We have one more criminal matter. It's People of the State of Michigan versus Gloria Jean Dabbs, file 25-7096FH. Counsel, you want to state your appearance beginning with people?
Melissa Goodrich, Glenn County Prosecutor.
No, Nightingale, for Miss Dabbs, who appears, I think in person. I can't see her though.
Yes, she is in the courtroom. And so, Mr. Nightingale, do you she did tell us that she spoke with you on Friday. So do you think this is fine to do it in this hybrid way, or do you want us to put her in a jail Zoom room to facilitate any breakout communication, or do you think we're good to go?
I think we're good to go, Judge.
Okay. All right. And this matter had been scheduled for a trial. It was removed off the trial docket based on an anticipated plea. And I think because of the jail cap on that and her credit, council wanted to move the hearing up to today for entry of a plea and sentencing. Is that how we're going to proceed today, Mr. Nightingale?
That is correct. Thank you, Judge.
Okay, and I do have the plea agreement and advice of rights. All right. A letter from Pastor Jones about her participation in jail services. All right, so Ms. Dabbs, this is going to be, and Ms. Goodrich, do you have an amended information or no?
I do not, Your Honor.
Okay, and that's 1 year and or is it a $200 to $500 fine?
I believe so. I can pull it up here in the meeting.
All right, well, Ms. Dabbs, under this.
I'm sorry, 200 to 1,000 and 5 days to 1 year in jail.
That's what I'm saying as well.
Okay, thank you. All right, so Ms. Dabbs, by this plea agreement, you'd be pleading guilty to an amended charge of operating while intoxicated, second offense. And that would be a misdemeanor punishable by 5 days to 1 year in jail.
Second offense, but it is her third. I hate how they do that.
And or a $200 to $100,000 fine. Do you understand that maximum penalty?
Yes.
Did you read and understand the rights listed on the advice of rights form?
Yes.
You understand that that form lists the rights that you give up by entering a plea instead of going to trial?
Yes.
And is that what you wish to do?
Yes.
The plea agreement provides in exchange for your plea to the misdemeanor charge, the felony would be dismissed. And there's a sentence agreement that you serve 6 months of incarceration. That'd be a straight jail sentence and credit for the time that you have been serving. Do you understand the terms of that plea agreement?
Yes.
Has anybody promised you anything else?
No.
Has anybody threatened you to make you plead?
No.
Is entering the plea your own free choice?
Yes.
Mr. Nightingale, are you aware of any other promises, threats, or inducements?
No, Your Honor.
Ms. Goodrich?
No, Your Honor.
All right, knowing all this, Ms. Dabbs, how do you wish to plead the charge of operating while intoxicated, second offense?
Yes.
So back on July 8th of 2025, were you operating a vehicle in Sheboygan County?
No.
Where were you operating a vehicle?
Judge, if the complaint date is actually incorrect. I believe the date was 7/3.
7/3, okay.
So I think that's why she says no.
Okay, very good. On July 3rd, were you up, and Ms. Goodrich, is that fine?
That is fine.
Okay. On July 3rd of last year, were you operating a motor vehicle in Sheboygan County?
Yes.
Okay. And were you operating that vehicle on a public highway, that being North Straits Highway?
Yes.
Before you operated that vehicle, had you consumed alcoholic beverages?
Yes.
Did you have some contact with police officers?
Yes.
Did they end up giving you a test to determine the amount of alcohol in your body?
Yes.
Do you remember the results of that test?
No.
Were they above the legal limit of 0.08?
Yes.
Okay, and you don't challenge that test result?
No.
And at that time, did you have a previous conviction for operating while intoxicated? Looks like most recently back in 2007 in Knox County, Tennessee.
I think the actual arrest was 2003, but conviction in 2007.
Okay.
But yes.
Okay. And Mr. Nightingale, that of course would be outside the 7-year window for an OWI second, but she's charged with a greater offense of the third within any period of time. So do you consent to the entry of the lesser offense?
I do. Thanks.
Okay. All right. Are you satisfied with that factual basis, Mr. Nightingale?
I am, Your Honor. Thank you.
Ms. Goodrich?
Yes.
All right, Ms. Dabbs, I find that your misdemeanor plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe that you're guilty of that offense. So I hereby accept your plea, and we can proceed to immediate sentencing then. By my calculation, Mr. Nightingale, I think I've got her at 152 days credit as of today, according to the jail log. Anything you want to say on her behalf?
Yes, Your Honor, please. So I do have her at 153, but I think one day, one way or the other is not going to matter at this point. Asking the court to accept the agreement of the parties here. Ms. Dabbs comes before the court, I believe 70 years of age. She has extremely limited criminal history. Her last conviction was about 20 years ago, and I think as she's informed the court that her recollection is that's actually a prior case that was dismissed and then refiled. And so it looks like it's later in time, but when in fact it was earlier in time. Nonetheless, 20 years, I think, since she's had any history like this, has no prior felonies. This was an incident from July 3rd of last year. There was no crash here. The 911 call does report some erratic driving behavior, but none was actually observed by the officer who pulls her over. Ms. Dabbs was fairly compliant, acted appropriately with the officers. Her blood alcohol content was a 0.113, so not a super drunk, but above the 0.08, as the court's already asked her about. So nothing particularly concerning about the facts of the case itself. I'm sure that the court, is obviously and always concerned with prior OWIs. We hope that since she's had 20 years since that last DUI, since this 6 months of jail is the top of the guidelines for her on an OWI third, that the court will accept this agreement, will consider it appropriate and reasonable under her specific circumstances, not place her on probation. She is on a fixed income. As to her person, Ms. Dabbs obviously received that letter from the pastor at the jail. She's obviously at least attempting to take her time in there seriously and rehabilitate not just herself, but some of the other people, the other folks that are in there. She is a lifelong educator, and I think that's not ever something that's going to leave her and something that she's taken to the jail with her. Trying to pass on her experience, to the younger folks that are in there. This case itself, I think Ms. Dabbs was certainly dealing with an amount of grief that she has not probably, really acknowledged or fully dealt with at this point. Her husband passed a few years ago at this point, I believe, but it was like a long and drawn out passing. I think that he had some sort of cancer, and through that treatment process, she was essentially bankrupted. Almost lost everything. Thankfully she's been able to keep her home, and that I think has been a big wake up call for her. This period of incarceration almost cost her home, and everything inside of it. And I don't think that this court's going to see Ms. Dabbs again, at least in this capacity. She is a good and fairly law-abiding member of the community, and I hope that this is the last time that she has this type of run-in with the law. We are very grateful for the plea agreement that Ms. Goodrich and I came to. I think that it fairly and appropriately deals with what happened here, and ask the court to accept the same. Thank you.
Thank you, Mr. Nightingale. Ms. Dabbs, you don't have to tell me anything today, but you're welcome to. Is there anything you want to tell me or no? Okay, that's fine.
I can't think of anything.
That's fine. Any recommendations from the people, Ms. Goodrich?
Yeah, sure. I'd be asking the court to follow the plea agreement. The beginning of this case was rough. Ms. Dabbs kept violating her bond, but yet didn't want to go to rehab or admit that she had an issue. I was really happy to see this letter from Pastor Jones that she's turned the corner and has invested in achieving sobriety, and also had the empathy to help others along the way. So I would ask the court to follow the plea agreement. Thank you.
Okay, thank you. Well, Ms. Dabbs, if you please stand for the court sentence. Well, Ms. Dabbs, you've got some prior convictions. They were a long time ago, which is why you've got this outcome here today, which I am going to follow. I share the prosecutor's concern about, that you seemed to be either unable or unwilling to stop drinking while you were on bond for this case. That does give me some worry about future, and with the history that you have now with a recent drunk driving. If you come back in front of me for a drunk driving, it will almost certainly be sending you to the state prison, which at your stage in life, I guarantee you do not want that to happen.
No,
So
I do not, but may I say something?
Sure.
I did not drink on bond.
Why did we revoke your bond?
They were dilutes.
Oh, okay. Well, then you were, yeah, okay.
But
That worries me even more.
But there was, according to several people I've talked to, it's from the caffeine that I was drinking. And unfortunately, eating pineapple, which I didn't know would eat the protein that's supposed to keep it from.
So Ms. Dabbs, I don't want to cut you off, but the judge is about to accept the agreement of the parties. And so
Yeah,
I would not
don't
make
worry,
any
I'm not
comments.
gonna, yeah, I'm not, he's worried because you're like giving me excuses, and that's usually not a good recipe for me to follow the agreement. But I'm not gonna hold that against her. I'm gonna follow the agreement, Mr. Nightingale.
Thank you, Judge.
But Ms. Dabbs, I guess I just want to tell you, I'm gonna follow this agreement, but I'm concerned that we're not done with you. And I guess I just want to promise you, you want to be done drinking and driving. I hope you're done drinking. But, if you want to get as drunk as you want in your own home, that's not going to be illegal for you. It's going to be bad for you given your history, but that's up to you. But if you get behind the wheel after you've been drinking, I promise you, you and I are going to have a very different interaction.
It won't happen again, Your Honor.
Okay. I sure hope you're right about that. I'm not in charge of that. You are. Okay. So understand, if in a year or two, I'm sending you to prison for another drunk driving, that's not my fault. That's going to be your fault and your decision. All right. Well, given the number of prior drunk drivings, I'm a bit reluctant about this, but the fact that they are so long ago and there's been such a length of time without problem, I'm going to follow the agreement this time and sentence you to 6 months in the Sheboygan County Jail with credit for 152 days credit. There's a state cost of $50, crime victims assessment of $75, $350 in court costs, and a $200 fine, penal fine, for a total of $675. And you have to make arrangements to pay that at the clerk's office. If you can't pay it in full, you can set up a payment plan with my staff at the circuit court. Because we are entering a judgment of sentence, you can file an application to appeal to the Court of Appeals. If you want a lawyer appointed for you, you'd have to ask me within 6 months. We're going to hand you a piece of paper about those appeal rights and ask you to initial one copy for us. And the other one is for you to fill out if you want to take an appeal. We'll get the judgment of sentence done today. And I imagine with credit, you should be released. The jail will calculate your out date. And then you're all set with us, other than paying that fine off. You won't be on probation. Okay. Good luck to you. Mr. Nightingale, I do have an amended information that has the operating second and the Knox County as a prior. Do you consent to its filing and waive its reading?
Do, Your Honor. Thank you.
Okay. All right. Thank you very much, Mr. Nightingale.
Thanks, Judge. Have a good day, and thanks for squeezing us in.
You too.
Kendall, I don't think your jokes are showing up. I don't think there's anything wrong with your jokes necessarily. I even responded to the last one. I gave my answer. I see you answered it the second time you posted it. I didn't see the answer on the first time you posted it. But no, it's not the wrong crowd, I promise you. We're all just very tired. Yes, very much so. It is cute. Whoa, my hair was doing a little sticking out the back thing there. Hello, Fairy Tale. Yeah, I'm off to bed too. I was struggling staying awake that last one. So but I thought those cases were all very interesting and I thought you guys would enjoy them. I try to keep the coffee to Kahlua ratio a little half and half. No, I'm just kidding. Yikes. Did you guys know that if you drink your mixed drinks with Diet Coke, your BAC will be higher than if you drink it with regular Coke with the same amount of liquor? It's true. They've done scientific studies on it. It is 100% true. I only saw the one, and I can't say it. I really can't. But what I can do is I can post it in Discord. Kendall, do you have Discord? Are you in there yet? Oh no, I hope you feel better soon, sweetie. Aww. They didn't mention that in the study. I don't know. I thought it was fascinating. So, if you drink Coca-Cola with vodka, just throwing that out there. I don't even know if that's a thing. But if you drink Coca-Cola with vodka, whether you eat, whether you don't eat, whether whatever the circumstances are, and you take a breathalyzer test after 2 drinks, right? And then you have the exact same circumstances of whether you've eaten, whether you've not eaten, whether the exact same platform of circumstances, but your drink is Diet Coke and vodka. Your BAC will be higher on the Diet Coke than it will on the Coke. I know. I'm sorry. Sugar slows the absorption of alcohol. If you drink it with Diet Cola, the alcohol gets absorbed faster. There we have the scientific reasoning. I didn't know the reason behind it. I just knew the answer. I didn't know the reason. Well, I don't know what you put. Malibu? I think Coke and Malibu is a thing, isn't it? I don't know. I don't drink, guys. I'm sorry. Rum and Coke. Okay, that makes more sense. I've heard of that one. I don't drink. I'm sorry. Now you guys know that I'm not lying. Oh. Well, if the alcohol didn't make you throw up, that would. Oh, okay. Yes, it does. It does. That's why you're not supposed to drink when you're diabetic. Decaf Diet Coke. What's the point? That's the gold can. I always thought there was no purpose to that. I didn't know people actually drank it. I thought it was just decoration. Just kidding. I really hope you feel better. I've struggled with sleep the last couple of nights. I've not been sleeping quite so well. That's probably why I'm dozing. I'm really, really, really struggling. No, I don't need the practice. I had enough practice when I was younger. A little too much. Oh, you mean the olive oil, maybe? The olive oil gives you a reason to start drinking? No. Again, no. Or eating before drinking. That's supposed to be helpful. Well, then what are you doing here? I'm just kidding. Yeah, but my subscribers, the ones who don't know me, tend to frown upon it when I doze off during the stream. I was this close. I was this close. I was struggling, man. I know my head was starting to tip. I was like, oh, I'm going down, I'm going down, I'm going down. Oh, I can do this, I can do this, I can do this. All right, guys. I'm gonna crawl in bed and see if Snitch will come cuddle with me. Where's my Snitch? Where's my Snitch? I thought I heard him. Must have been Tiny Kitten. She's over there. But thank you guys so much for coming and hanging out with me. I hope you enjoyed the cases. I liked them. I really liked them tonight. April was so tired she didn't even see you saying that she was tired. I might have had to agree with you. Well, Wolf Lore Lover says he needs you. I'm not sure. To be 100% honest, I like anytime another court case streamer type person like pops up on my YouTube, I do the don't recommend channel thing. I do that for a very good reason though. For one, I don't want to be accused of stealing other people's stuff or of getting my ideas from other channels, you know, like I don't want people to say, oh, she takes all of her content from other people who's posted it. No, I don't ever want to be accused of that. I go out and I find my own cases, I edit my own cases, and I post my own cases. The other reason is editing takes a long time. And there were a few times before I started blocking all the other court channels, there were a few times where I would spend 6 hours a day editing a particular case, so excited that I found it. And then another streamer would post it or another content creator would post it. And I would scrap the entire editing job because they've already posted it and they had more viewers than I honestly, I have 7,000 subscribers. The average videos are around like 173 views for the live streams ish. So, they don't get seen a lot. The replay crew minis did get seen a lot more, but that was a lot of work, a lot of work. And I needed to take a break because I had a lot of responsibilities around here that I was neglecting on and that I had to get taken care of. I had to deal with the probate matters for my parents' house. My car accident case stuff was still going on. Dealing with all the animals, and I lost my cleaning person. I lost all of my medical services. So then I had to, drive myself to all my appointments, and it was just too much. I needed to take a step back, and the only thing that I could take a step back from was YouTube. So I had to do that. So right now, I'm not getting a ton of views, and I'm okay with it. I'll get back to doing the replay crew minis eventually, and I'll get back to getting my viewership up, and life will go on. I'm cuddling with Snitch and Ava and Billy and Earl. Excuse me. Bandit stays in her room, and Tiny Kitten doesn't cuddle. Excuse me. I love you too. And I saw Mortimer Duke. I'm sorry that I missed Wordle last night. I think I did. I think I missed it. I'm sorry. I'm a horrible team member. You should dump me, for real. I love you. Thank you so much for at least stopping in and saying hi. You just want to look at Judge Mogan. She is quite beautiful. She just talks so much. More than me. It's a Wisconsin girl thing. If you look up Victoria Justice, she has a song where she falls in love with an alien and has a video where they get disturbingly intimate. I don't remember that one. I don't remember that one at all. Okay, guys, quit it. You keep saying interesting things or things that I want to comment on. I gotta go to bed. I love you all, and you know that. You're addictive. Be safe, be well, sleep sweet, and much love.